There's a disturbing political trend in America that's quietly eroding the most basic constitutional rights for all Americans. As the United States engages in the second continuous decade in the War on Terror, whistleblowers have alerted the public to horrific sacrifices made to their constitutional rights in the name of national security.
The major structural assaults carried out by the Bush administration have been embraced by the Obama administration, all of them. Whether it is the expansion of imperial war, drone attacks, the looting of the U.S. Treasury by Wall Street, most importantly, the assault on civil liberties.
The federal government has proven that through its secret interpretation of broadly written federal laws, it can authorize actions that would otherwise be restricted by the Constitution.
The fact is, anyone can read the plain text of the Patriot Act, and yet many members of Congress have no idea how the law is being secretly interpreted by the executive branch because that interpretation is classified. It's almost as if there were two Patriot Acts, and many members of Congress have not read the one that matters. Our constituents, of course, are totally in the dark. Members of the public have no access to the secret legal interpretations, so they have no idea what their government believes the law actually means.
Since the beginning of the War on Terror, now the longest war in American history, the American public has discovered a number of federal actions that clearly conflict with the Constitution.
We cannot wait for the final proof, the smoking gun, that could come in the form of a mushroom cloud.
The use of national security letters and gag orders have suppressed Americans' freedom of speech. The massive increase in federal prosecutions of journalists and whistleblowers have censored the freedom of the press.
When Barack Obama ran for office, he promised to lead the most transparent administration in history. But when it comes to his whistleblower policies, the only thing that's transparent about the president is how much he values secrecy over openness. His administration has charged more whistleblowers under the Espionage Act than every other president combined.
The warrantless spying and stockpiling of Americans' digital communications has effectively suspended the Fourth Amendment.
The NSA is collecting the telephone records of every single human being in the United States without any regard to whether they engage in wrongdoing. They're tapping into their online chats, their online calls, their online interactions of every sort.
The use of weaponized drones and the indefinite detention of people without a trial conflicts with the due process rights protected by the Fifth Amendment. And the use of torture techniques disguised as enhanced interrogation has violated constitutional treaties as well as the Eighth Amendment. In many cases, these constitutional violations continued for years before the public or even the federal courts had the knowledge to stop them. It was through the use of secret interpretations that the federal executive branch exposed its unobstructed ability to subvert the Constitution and the legal oversight of the judicial branch.
The ACLU and other groups have been trying for 5 years now to go into court and challenge the constitutionality of the surveillance law by claiming that it violates the Fourth Amendment. We do have a constitution in the United States regarding searches and seizures, and the U.S. government has successfully blocked any challenge on the grounds that, well, we keep it a secret who it is that we eavesdrop on, and because we keep it a secret, no one person can say they've been eavesdropped on and therefore doesn't have standing in court to challenge the law.
The debate between the protection of civil liberties and the advancement of national security dates back to the very creation of the United States. Since the attacks on 9/11, all branches of the federal government have proven unable to maintain a constitutional balance in this debate, prioritizing national security at all costs.
My whistleblowing actually started in 2001, shortly after 9/11, which, much to my horror, the United States essentially conducted a coup against the Constitution and unchained itself from the rule of law and engaged in a whole series of activities, including the very foundational programs of mass surveillance.
Well, I think that the laws that were passed, again, post 9/11, gave very broad authority, and it was endorsed by executives in two administrations, both Bush and Obama. But the fact is that the Fourth Amendment is plain. It says you need a warrant. That the Congress is trying to square Americans' constitutional right under the Fourth Amendment and the necessity for information that can be connected to terrorist activity here at home or abroad. It's a really difficult balancing act.
In attempts to safeguard civil liberties, civil rights activists are beginning to remember age-old solutions that also stem from early American history. The framers of the Constitution created two different systems of checks and balances in order to prevent tyranny and to protect the constitutional rights of the people. The first system is the horizontal division of power. This is known as the checks and balances between the three branches of government, the legislative, executive, and judiciary. The other system is a vertical division of power, called federalism. In federalism, power is divided between the central federal government and the government of the states. The concept of federalism may play a crucial role in protecting the constitutional rights of Americans from the unrestricted interpreting power of the president and the federal executive branch.
This raises a really interesting problem, and one that I think we should pursue with our ordinance, and that is, what if one branch of government, one type of government, is trying to enforce its laws when those laws are unconstitutional, and when the people in Lane County, through their elected government or through initiative, have passed their own law?
Unfortunately today, the history and original intent of the federalist system is either misunderstood or deeply ignored by much of the American public and their governmental representatives. This dangerous misunderstanding is fueled by the modern interpretations of Article 6, Section 2 of the U.S. Constitution, known as the Supremacy Clause. Many modern interpreters of this clause believe it forces states to comply with every and any federal law that is passed and federally interpreted. Thanks to whistleblowers, the American public has witnessed an increased trend in federal laws that have been secretly interpreted to deny the constitutional rights of the people. As citizens become more concerned with the potential threats of an out-of-control president and executive branch, it is important for citizens to relearn the important civil protections offered by our federalist form of government. One of the earliest demonstrations of American federalism was written in the Virginia and Kentucky resolutions by Thomas Jefferson and the father of the Constitution, James Madison, in 1798. Within 10 years of signing the Constitution, the federal government passed the Alien and Sedition Acts that severely violated the First Amendment rights of the American people. The Virginia and Kentucky resolutions simply outlined the constitutional role of the states when confronted with such unconstitutional laws. The Kentucky legislature passed Thomas Jefferson's resolution, which stated, "The several states composing the United States of America are not united on the principle of unlimited submission to their general government. Whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force." Similarly, Virginia's resolution, written by James Madison, stated, "In case of deliberate, palpable, and dangerous exercise of other powers not granted by the said compact, the states who are parties thereof have the right and are in duty bound to interpose for arresting the progress of evil, and for maintaining within their respective limits the authorities, rights, and liberties appertaining to them." These resolutions outline two important constitutional principles. State governments have the power to disobey federal laws and orders that clearly conflict with the Constitution, and states are duty-bound, meaning required to stop the progress of any unconstitutional actions carried out by the federal government in their jurisdictions. American federalism is designed to protect the Constitution and the rights of the people in two ways. It gives the rights of the federal government to assure local jurisdictions are not infringing upon the constitutional rights of their residents, like we've seen before in cases surrounding issues of discrimination, segregation, and equality under the rule of law. However, our federalist system also provides that same responsibility to the states to assure the federal government doesn't violate the rights of the people, as we're beginning to see more and more in this new age of terror. In 2012, a dangerous new anti-terrorism law was enacted that has become one of the clearest examples for the need to reaffirm that system of federalism. Even in 2017, many civil rights groups agree the law remains one of the greatest threats to Americans' constitutional rights.
In a scathing statement, the head of the ACLU said that Mr. Obama's decision to sign the National Defense Authorization Act, or NDAA, including the controversial detainee provisions, would tarnish his presidency. Quote, "President Obama's action is a blight on his legacy because he will forever be known as the president who signed indefinite detention without charge or trial into law." Human Rights Watch chastised the president even before the act was signed.
Codifying indefinite detention inside the U.S., mandating military detention for all terrorism suspects found inside the U.S. would really set the U.S. back, decades in terms of how we approach terrorism.
When communities across the United States attempted to protect their residents from the law's unconstitutional use, a number of shocking political and financial roadblocks were exposed. These roadblocks not only attempted to ignore the founding principles of American federalism, but seemingly prevented state officials and their residents from protecting even the most basic constitutional rights from federal abuse.
My interest in this, is to protect the rights of our citizens. At the same time, we have to balance the protection of those rights with our duty to our oath to uphold the laws of the United States, and also to our fiscal responsibilities to the citizens. The last update we got from legal counsel, I believe, was in December of last year, was so devastating about the negative impacts of a county ordinance. And at that time, we basically looked at each other in stunned silence and let it die.
In part 2 of this video, you will find out why this new anti-terrorism law poses the greatest threat to Americans' constitutional rights, and why the protections provided by the federalist system may be the only way to stop it. In part 3, you will see firsthand the political and financial roadblocks that are commonly used to strip states and communities the ability to protect their residents' constitutional rights from federal abuse. In this particular Federalist case study, the residents of the state of Oregon attempted to enact state and local laws that guaranteed their residents the right to a trial from being denied by the new anti-terrorism law. They were eventually told by top state officials that the new terrorism law did in fact deny citizens the right to a trial, but that it would be unconstitutional to pass local laws to restrict its use. This is the true story of the NDAA and the corrupted understanding of the Federalist system.
Within the system of power, with a conscience, who rises up to expose war crimes committed by our government, will no longer speak. And finally, the NDAA. And you have to ask why. Why is there steady assault, stripping away of our most cherished civil liberties? What's happening? They know that eventually there will be blowback. Eventually people will respond. And they want the powers to, in essence, criminalize any form of dissent. And that's what this is about.
The House is expected to vote today on a massive $662 billion defense bill that would usher in a radical expansion of indefinite detention under the U.S. government. A provision in the National Defense Authorization Act would authorize the military to jail anyone it considers a terrorism suspect anywhere in the world without charge or trial. The measure would effectively extend the definition of what's considered the U.S. military's battlefield to anywhere in the world, including the United States. Its authors, Democratic Senator Carl Levin of Michigan and Republican Senator John McCain of Arizona, have been campaigning for its passage in a bipartisan effort.
We will incarcerate people preventively, preventive incarceration, indefinite detention without trial. That's what this is.
A bill written in secret by Senator McCain and Senator Carl Levin that would give the U.S. military and not civilian law enforcement agencies the ability to arrest anyone and hold that person indefinitely, even if that person is an American arrested on American soil.
They affirm in statute for the first time a power that the president has merely claimed, and that's the power to detain indefinitely American citizens without charge or trial.
That should be of grave concern to all Americans who care about our constitutional rights to a fair hearing.
Basically, to take them out of the criminal justice system and remove from them the protections that are, quote, guaranteed, close quote, by the Constitution.
This is right. I mean, this is about the egregious destruction of the rule of law.
The new anti-terrorism provisions found in the 2012 National Defense Authorization Act, NDAA, has become one of the best examples in the 21st century for the need to reevaluate our legal systems designed to protect Americans' constitutional rights. The legal history of the NDAA clearly demonstrates a failure of the federal three-branch system of checks and balances, and emphasizes the need for additional safeguards at the state level through the system of federalism. Section 1021 of the 2012 NDAA authorizes the U.S. military to operate inside the United States to target American citizens under the laws of war. Once operating under the law of war, Americans can be denied all the legal rights normally guaranteed by the Constitution and the American justice system. Section 1021 allows the military to selectively imprison American citizens without a trial till the end of the War on Terror. This provision is now commonly known as indefinite detention due to the unlikelihood of ever ending a war on a concept like terror. Civil rights groups fear that this law, similar to other controversial anti-terrorism laws outlined in Part 1, could be secretly interpreted and used by the federal executive branch for years before being stopped by the courts.
But isn't this the perfect catch-22? Because we can't have the evidence that proves that this exists to challenge it
and that it's being
abused. And that it's being abused without somebody coming forward like an Edward Snowden.
So how could a law with such clear and numerous constitutional violations remain in effect to this day? To answer this question, we must look at how this law slipped through the cracks of all three branches of the federal government. This law first had to be introduced and approved by both houses of Congress, which in 2011 had one of the lowest public approval ratings in the nation's history. Despite some debates concerning the indefinite detention provisions, the bill was overwhelmingly passed by both the House of Representatives and the Senate.
In the last 10 years, we have begun to let go of our freedoms, bit by bit, with each new executive order, court decision, and yes, act of Congress. The changes in this bill to the laws of detention have major implications for our fundamental rights. Whoever it reaches, the government would have the authority to lock them up without trial until, quote, the end of hostilities, unquote, which, given how broadly the AUMF has been used to justify actions far from Afghanistan, might mean forever.
The authors of the new radical detention policies, Democrat Carl Levin and Republican John McCain, defended it by saying it gives the government, quote, the clear authority, tools, and flexibility of action it needs to defend us against the threat posed by al-Qaeda, end of quote. You know, it's a sad day when the only time Democrats and Republicans can come together is to subvert the Constitution and lay the groundwork for endless war.
In December 2011, the bill had made its way to the president's desk for the signature of approval. President Obama had previously threatened to veto the bill if it came to his desk containing the indefinite detention provisions of Section 1021. Obama's veto of the 2012 NDAA would have been a classic example of a functioning system of checks and balances. However, the Obama administration did something extremely unusual.
The good news in all that is that it shows that if the president follows through on his veto threat, his veto could be sustained, because the only way a veto can be overridden is with 2/3 of the vote.
As feared, the administration announcing today the president will not veto a bill that allows American citizens to be indefinitely detained without trial on American soil if there is even a suspicion they might have ties to terrorists.
The president has signed a defense authorization bill expanding executive powers concerning the detention, interrogation, and prosecution of suspected terrorists.
On New Year's Eve of 2011, he signed the 2012 NDAA into law with a signing statement that acknowledged the unconstitutional powers it gave the government to indefinitely detain Americans without the right to a trial. In other words, he signed a bill into law that he admittedly knew was unconstitutional.
On New Year's Eve, in this 1,800-word signing statement, the president seemed to emphasize the point, quote, my administration will not authorize the indefinite military detention without trial of American citizens. While voicing reservations, Mr. Obama signed the act.
Although Obama's signing statement promised his administration wouldn't use the indefinite detention powers, he knowingly left those powers available for future administrations.
This has never been done before. It is completely outside of the realm of what's constitutionally permissible.
He signed the damn bill. So even if his administration chooses not to interpret it in that way,
Well, then guess what? That doesn't stop any future presidents from using it in the exact language that it was written in.
Human rights groups among the president's core supporters on the left say future presidents may apply the law differently, adding the act is a sweeping expansion of executive power beyond what was seen under the Bush administration.
Particularly to hear President Obama claim the power to keep people in prison indefinitely with no charges against them, no conviction, no sentence, just imprisonment.
Civil rights groups and activists were equally shocked how the constitutional professor turned president could so recklessly endanger the constitutional rights of every American. According to our grade school civic books, after a law is passed by Congress and signed by the president, it is up to the courts to rule on its constitutionality. To get this law reviewed by the courts and ruled unconstitutional, a group of constitutional lawyers, civil rights activists, and journalists filed a lawsuit against the Obama administration. This landmark lawsuit is called Hedges versus Obama. The plaintiffs in the case included Pulitzer Prize-winning journalist Christopher Hedges, whistleblower and activist Daniel Ellsberg, historian and professor Noam Chomsky, as well as other civil rights activists and whistleblowers. They argued that their First Amendment right as journalists and civil rights activists were violated because of the serious legal threats posed by the vague language in Section 1021 of the 2012 NDAA. Section 1021 makes two dangerously broad classifications for those who can be subjected to indefinite detention without a trial. These include, number 1, anyone who is suspected of substantially supporting Al-Qaeda or their associated forces. And number 2, anyone who is suspected of causing a belligerent act against the United States.
You see with almost each passing year, the government keeps pressing the outer boundaries of who they can target. First it's Al-Qaeda, then it's, quote, associated forces. They're expert at making up these squishy terms like co-belligerents, and they keep expanding the target for the government to the point where now we're involved in military action in Yemen, Somalia, Libya, Niger. I mean, it's ever expanding, and that's how the law has been going too. First the outer reaches were at the Holder statute, the anti-terrorism statute, where it's material, and now the NDAA has gone to substantial support, which could be construed as journalism or writing. And so the progression is going in the wrong direction, and it's only if citizens fight back via protest or in litigation that we're going to stop this, because I see no effort by either party to stop this.
By passing this dangerous law with such vague definitions, Congress has given the sole authority to the president and the executive branch to determine in secret what actions may be considered a belligerent act or substantial support. Could a political protest similar to the Occupy movement or a Tea Party rally be considered belligerent acts? Could investigative journalists or future whistleblowers covering the war on terror be considered substantially supporting Al-Qaeda or their undefined associated forces? The federal judge who first reviewed the claims made by the plaintiffs in the case quickly ruled that Section 1021 was facially unconstitutional and stated that it had a chilling impact on the First Amendment. She concluded her ruling by prohibiting the government from detaining any individuals using the powers granted by Section 1021.
Reading Judge Forrest's opinion last night, which is well worth doing. I didn't read every word. I went through every word, the 112 pages, and read a lot of it quite carefully because it was fascinating. And one thing that struck me very much was here is somebody actually taking the Constitution seriously and the rights seriously, as though they weren't just a piece of paper, but were really important to interpret and preserve.
And this is why people cease to speak out. I mean, I am sure the government's not setting up massive internment camps for journalists and activists. But the very fact that these powers exist is what diminishes free speech and the commitment to free speech. And every time we have a law like this, that commitment is eroded further and further downward. And that's what we're fighting against.
In a functioning system of checks and balances, this is where the legal story should have ended, but unfortunately it was just the beginning. Despite the Obama administration's original opposition for the indefinite detention provisions, They immediately appealed the judge's decision in order to keep them.
The news: civil liberty advocates led by journalists and writers Chris Hedges, Daniel Ellsberg, and Noam Chomsky secured a big victory yesterday. Federal Judge Catherine Forrest struck down the controversial indefinite detention provision passed and signed by President Obama on New Year's Eve last year as part of the National Defense Authorization Act, or the NDAA. Judge Forrester agreed with the plaintiffs that the provision could chill the First Amendment and leave journalists vulnerable to indefinite detention if they associate with terrorist organizations while trying to cover stories. The Obama administration is appealing the ruling. But joining me now to explain what this ruling means and where we go from here is one of the lead plaintiffs in the case, investigative journalist Chris Hedges, the author of numerous best-selling books, including his latest, Days of Destruction, Days of Revolt. Chris, welcome back.
Thank you, Tom.
Great to see you. To begin with, what did you argue were the consequences of this indefinite detention provision?
Well, this provision, Section 1021 of the National Defense Authorization Act, which, as you pointed out, was signed by Obama into law on December 31st, overturned 200 years of legal precedent authorizing the military to carry out detentions of U.S. citizens, those deemed to be terrorists associated with al-Qaeda or the Taliban, or what they nebulously termed associated forces. These people could be held in military facilities, including in our offshore penal colonies, without access to due process until, in the language of this section of the law, until the end of hostilities, which in an age of permanent war is forever. There's no exemption in there for journalists. This was a gross violation of basic constitutional rights to courts and to legal representation. In the final hearing in the first week of August, she brought up the 110,000 Japanese Americans who had been held in detention camps in World War II in similar circumstances, and she struck down this provision. It's a fascinating 122-page ruling, which is quite strident in terms of its condemnation of the government, the executive branch's destruction of the separation of powers. It's really quite a remarkable judicial ruling. We know the Obama administration will appeal. They already have appealed.
Why do you think this provision was so important to them? Why did they put it in there in the first place, and why are they fighting to keep it?
In the name of the battle against the war on terror, creating a legal system by which any form of legitimate dissent, especially if it's dissent that mushrooms into a mass movement, can be shut down.
That's extraordinary. Chris Hedges, thanks so much for being with us tonight.
When the case was reviewed by the Second Circuit Court of Appeals, the appeals judge refused to rule on the constitutionality of the provisions. Instead, the judge threw out the entire case by ruling that the plaintiffs couldn't prove that they had been specifically targeted by the law and lacked the legal standing to bring the lawsuit in the first place.
And because we keep it a secret, no one person can say they've been eavesdropped on and therefore doesn't have standing in court to challenge the law. So if you want to talk about legality, the Obama Justice Department has repeatedly blocked courts from ruling on the legality, namely the constitutionality of this law. If they think it's so legal, let there be a challenge in court.
The Obama administration had won back its power to indefinitely detain Americans without a trial. The plaintiffs in the case then appealed the last judge's decision, sending the request to the Supreme Court to make a final review of the case. On April 28, 2014, the Supreme Court officially denied the request for review, leaving the full indefinite detention provisions intact. The appeals judge's decision to throw out the case, overturning the previous federal judge's ruling, further demonstrates the judicial branch's inability to restrict secret actions of the federal executive branch.
And the courts have increasingly, in the wake of the post 9/11 period, become reluctant to scrutinize any decisions or programs that were constitutionally questionable, saying that they lacked the expertise or the positioning, or what it ultimately boiled down to was the political willingness.
He's a member of the Senate Select Committee on Intelligence. Senator Wyden, thank you so much for being here tonight.
Thanks for having me again. I think the American people certainly know more about the fundamental question, which is we have to strike a better balance, Rachel, between protecting our security and protecting our liberty. I've just come off a 2-year effort, made 7 separate requests to get the Obama administration to release these previously secret legal analyses which offer the justification for the drone strikes. And this debate is just beginning, and the reason I went to the floor today is I thought it was an opportune time to try to show that there is a new effort by both progressives and conservatives to try to show that in our country it's possible both to protect our liberties and at the same time ensure that we're vigilant against the very real threats that are out there.
Simply put, again, to make the point that the senator from Oregon made so importantly, I believe that Congress is granting powers to the executive branch that lead to abuse and, frankly, shield the executive branch from accountability. In Federalist 51, James Madison, who we venerate, who was the author of many of the documents that structure and way in which we organize and operate our democracy, he wrote, quote, "In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself." The bill before us does not live up to that standard, and I believe it seriously risks the constitutional freedoms of our people. We need to strike a better balance between giving our national security and law enforcement officials the tools necessary to keep us safe while not damaging the very Constitution we have sworn to support and defend. Before I yield the floor, Mr. President, I want to make one last historical reference. Ben Franklin, one of our founding fathers, said compellingly and presciently, he said, "A society that would sacrifice essential liberties for short-term security deserves neither."
NSA's charter, and it was a legitimate one, was to do foreign intelligence, and I was with that all the way, and I did the best I could in that job. Unfortunately, they took those programs that I built and turned them on you, and I'm sorry for that. I didn't intend that. Tell me something that will implicate somebody in a crime. That's what they asked me. So I told them what the crime was that I knew about, and that was that George Bush, Dick Cheney, Tenet, and Hayden conspired to subvert the Constitution, the constitutional process, and any number of laws, and here's how they did it, and I explained stellar wind on my back porch to all the FBI agents who weren't cleared. So they had a problem. I created a problem for them because they had a bunch of people now who weren't cleared for a very highly classified, only because it was domestic spying, by the way, was the reason it was highly classified. They wanted to highly classify the extreme impeachable crimes that they were committing.
As it stands, through the passage of the 2012 NDAA, Congress gave the President and the executive branch the unchecked power to secretly capture and detain American citizens anywhere in the world without a trial, including inside the United States. To make matters worse, and increasing the difficulty of finding people with legal standing to challenge the law in court, are the provisions also found in Section 1021. These sections authorize suspected citizens to be secretly deported using rendition to anywhere in the world, including military prisons and black sites. These facilities, similar to the infamous Abu Ghraib prison, where countless acts of torture were also secretly interpreted and authorized by the executive branch as enhanced interrogation techniques. Until the law is amended by Congress, the only way to prevent the secret, unconstitutional use of the 2012 NDAA is through the states. By embracing the constitutional responsibility of the 10th Amendment and the founding principles of the federal system, state officials could pass laws that restrict how the law could be interpreted inside their jurisdictions. These laws would not only safeguard the civil rights of their residents, but would also act as an early alert system for the public and the courts to review. A number of jurisdictions around the country attempted this approach with varying degrees of success. Part 3 of this video series exposes exactly how local and state governments refuse or are pressured into neglecting their lawful responsibility to protect the constitutional rights of their residents from federal abuse.
This is something the KGB, the Stasi, or the Gestapo would have loved to have had about their populations. So, I mean, and just because we call ourselves a democracy, right,
doesn't mean we will stay that way. That's the real danger. And we, the people, may have absolutely nothing to say about it. We haven't had anything to say so far.
As we have seen in part 2 of this video series, the indefinite detention provisions of the 2012 NDAA survived constitutional challenge by each branch of the federal government. Its legal history provokes a number of interesting questions surrounding the full understanding of the Supremacy Clause, as well as the responsibility of the states in our federalist form of government. The federal appeals judge, who threw out the lawsuit against the NDAA, indirectly overturned the previous federal judge's ruling that the law was unconstitutional. Does this somehow mean that the indefinite detention of Americans without a trial is now constitutional? If the central government decides to do nothing to change this law, are the states and the American people forced to live with it? Like the interpretations of the Patriot Act and torture disguised as enhanced interrogation, will it take more than a decade before the American public and the courts realize how the vague language of the NDAA was secretly interpreted to suspend the rights of Americans? Shockingly, the answers to these questions differ depending on a person, or more importantly, an elected official's understanding of the Supremacy Clause and the concepts of American federalism. To explore the answers to these critical questions, we'll take an in-depth look at the state of Oregon's actions against the indefinite detention provisions of the NDAA. Oregon had a broad, nonpartisan coalition of citizens who recognized the inability of Congress and the federal courts to restrict how the NDAA could be secretly used by the president and the federal executive branch. Many were determined to have their state and local jurisdictions enact local laws that would clearly outline how the law could be legally interpreted in their jurisdictions. First, organized citizens from 5 different counties got their elected officials to sign resolutions acknowledging the real constitutional threats that the indefinite detention provisions created. Secondly, once the problem had been officially recognized, citizens urged their officials to begin passing necessary legislation to protect their rights.
The first 2 paragraphs of my remarks have already been spoken by speakers before me from the left and the right, and to me there is no irony in that at all. It really boils down to whether or not our constitutional rights still matter to you, the commissioners, matter to our government. Now we see in sections 1021 and 1022 of the NDAA that someone has decided that these things no longer matter. This is the law of the land. That armed agents of the government can now come to your home in the dead of night, enter forcibly without a warrant, arrest you and members of your family, and detain you indefinitely without formal charges. Our commissioners are the only people in this room who can take official and effective actions against these outrageous sections of the NDAA. Now, if all this really does matter to you, then please consider an ordinance that requires that no resources of Lane County government, including its law enforcement resources, shall be used against American citizens in support of sections 1021 and 1022 of the NDAA. Thank you very much.
Citizens rightfully reminded their officials of their oath of office, which legally requires them to support and uphold the U.S. Constitution and the Constitution of the state, both of which have numerous sections that guarantee all individuals the right to a trial, something that the NDAA attempts to deny.
Would encourage you with the strongest possible means to pass the ordinance to take the opportunity to protect the citizens of this county. Your authority to do that comes from the U.S. Constitution, particularly in the limitations of federal government in Article 1, Section 8, Paragraph 17, in the 10th Amendment, both the state constitution and the Act of 1859 of bringing Oregon into the Union of States.
These attempts to pass local laws have become vital in exposing a number of common political and financial roadblocks that can dangerously limit the officials in any state from protecting even the most basic constitutional rights from federal abuse. The legal team at the national civil rights group PANDA, the People Against the National Defense Authorization Act, provided language for a proposed law that would assure the protection of Oregonians' constitutional rights. The proposed law simply exemplified a long-standing Supreme Court precedent, Ex parte Milligan, that prohibits any state or federal employees from knowingly assisting in carrying out the laws of war on citizens inside the United States. The prohibition of the law of war is the most important clarification. The application of the law of war is what authorizes the denial of citizens' rights guaranteed by the Constitution and the American justice system. According to Section 1021, American citizens placed under the law of war can now be legally captured and held by the military for life without the right to a trial. Because the law of war so explicitly violates numerous constitutional rights, PANDA's proposed law rightfully creates criminal penalties for any person who knowingly assists in its illegal implementation. To put it simply, the proposed law criminalizes clear unconstitutional interpretations of federal law at the local level. It doesn't restrict any federal or local entity until they begin operating outside the American justice system and utilizing the law of war to detain and capture citizens. The proposed law was introduced at both the state and county level, and each exposed different but equally shocking results. Oregon's state constitution gives tremendous power to local jurisdictions under the authority called Home Rule. In fact, according to an essay written by the Association of Oregon Counties, and I quote, "The U.S. Advisory Commission on Intergovernmental Relations concluded, Oregon counties have a greater degree of local discretionary authorities than counties in any other state." In April 2014, due to public demand, the commissioners of Lane County, Oregon held a public hearing on the effects of the NDAA, and more than 300 residents attended. At the beginning of the meeting, a presentation was given on how the county could use their home rule authority to pass an ordinance, a county law, that could restrict the unconstitutional use of the NDAA.
Some county ordinances address purely local concerns unrelated to state law, but the bulk of county legislation supplement, amplifies, and otherwise assists in performing duties that state law imposes on counties. Well, one of the state laws that we have here is the state constitution, and we also have the U.S. Constitution that must be enforced in the state of Oregon, and therefore our ordinance would just amplify here in Lane County those due process protections that are reiterated in the Fifth Amendment, the 14th Amendment, as well as in sections of our own state constitution.
After the presentation, dozens of residents from all across the political spectrum made public comments demanding the passage of an ordinance that would safeguard their rights.
I'm also the chair of the platform committee of the Democratic Party of Lane County. We want Lane County to create an ordinance to ensure that anyone detained in Lane County is assured of due process.
And I'm an executive committee member of the Lane County Republican Party, as well as a voting member of the Oregon State Central Committee, to create an ordinance, not a resolution, but an ordinance countywide reaffirming the First, Fourth, Fifth, and 14th Amendments to be upheld against any federal agencies acting under detention powers granted by the NDAA.
I grew up and lived not too far from the Japanese internment camps in Toluca, California. It's a reminder of what can happen to a group of American citizens living here today. They can be rounded up and they can be detained by the use of military force all in the name of national security.
Creating laws to nullify these provisions is the just and honorable thing to do.
Take the courage to pass an ordinance.
An unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protection.
Because I've learned a lot about the home rule. And I think that Lane County has such an exciting opportunity.
We've got to stand up to this, all of us. All of us as individuals, all of us at every level of government have to protect the Constitution. The supreme law of the land is the Constitution. And it has power only if people demand it. And I would like to see a law, an ordinance as suggested here earlier, that you will not support any federal officer attempting to exercise any authority here that violates the Constitution as you understand it, and it's not that hard to understand.
I started the first grade in a logging camp in northwestern Oregon. And the first grade, they came and took a Japanese family away. They worked on the section crew. I never saw them again. A few years back, I looked on the internet and I found that they had both passed away. So history repeats itself, and we don't want this to happen in our country. God bless America. Thank you very much. And we all have something in common, and that's the Constitution. And if we don't live by these standards and let that be the founding that our forefathers set up, we're going to miss the boat, and we don't want to give that up. Thank you very much, and thanks to all the folks that are here. Thank you, Mr. President.
After more than 2 hours of public testimonies, all 4 commissioners in attendance publicly responded in favor of enacting a local ordinance.
This raises a really interesting problem, and one that I think we should pursue with our ordinance, and that is, what if one branch of government, one type of government, is trying to enforce its laws when those laws are unconstitutional, and when the people in Lane County, through their elected government or through initiative, have passed their own law. So I do think we should move forward on the ordinance.
We've heard from college Republicans to the Democrat Party of Lane County, from 9/12 groups to Occupy folks. It's really great to see such a diverse group of our citizens speak out in favor of our constitutional rights. All that is required for evil to flourish in the world is for good men to do nothing. Under our home rule charter, we are the good men that can either do something or do nothing. And I really think it's important that Lane County take a very affirmative stance against the possible unconstitutional interpretations of Section 1021 and 1022 of the 2012 National Defense Authorization Act. And I think we should ask that county resources not be utilized for the carrying out of any use of this act in unconstitutional matters. And I would even go as far as looking to have provisions in that ordinance that would hold people accountable and prosecute them for assisting in the enforcement of this act. Tonight, you presented a vehicle which possibly could be used that I would like to research, and that's an ordinance, and an ordinance that says that no county resources will be expended to cooperate with the NDA Act 1021 and 1022. You know, it is something that really is it's important that we all understand the social responsibility of civil disobedience, and the social responsibility of being able to step out against acts by the government that we disagree with, and that we feel to be either unconstitutional or unconscionable.
When Panda's ordinance was introduced, the commissioners directed their legal counsel to give a full review of the proposal. A month later, when the unelected legal counsel returned, they were negligently unprepared and clearly demonstrated an unwillingness to uphold the rights of Lane County residents through the passage of an ordinance.
Proposed ordinance that was forwarded by Panda, and I believe it was forwarded to Commissioner Bozovich and Commissioner Stewart. So that's how I ended up with it. So within the 15-minute rule, and based on my previous contact with it, I'm not sure exactly what was wanted today, but I'll quickly report that I did look at the proposed ordinance. As some of the speakers mentioned, I have concerns about the way it's written as to whether or not it's whether it would survive constitutional challenge, because it doesn't have a culpable mental state, and the Supreme Court of Oregon has said that you have to have a culpable mental state. Essentially, it makes it a strict liability crime. I'm also concerned that it doesn't, how a person would know that, how an individual employee would know that they were enforcing an unconstitutional statute if the statute had not been declared unconstitutional.
Despite the legal counsel's attempts to reject the ordinance, the commissioners pushed back and seemed eager to finalize the law's enactment.
Questions or comments from Ms. Bingle? Commissioner Bozovich. Thank you.
First, I'd like to clarify. I think we had 3 head nods from the board to go beyond 15 minutes analysis.
I wasn't clear about that.
Okay.
That's why I was asking, seeking direction.
Okay, so maybe if there does need to be additional review, I think we had, only a single board member is limited to taking up 15 minutes of staff time. If there's a quorum of the board that says it's okay to go beyond 15, which is what we got, that's what the direction was to go beyond the 15. Quick question about culpable mental state. Is that just a matter of adding a clause to the ordinance that refers to needing to be in culpable mental state?
Well, it has to say that the person is intentionally or knowingly doing what they're doing. Which is under Oregon is.
Would this be similar to a culpable mental state in aiding and abetting in the carrying out of a felony or harboring a fugitive? Those kind of crimes that are that you may not know you're committing at the time, and they have to go back and determine whether you knew or not, and whether you were culpable. Or the ordinance that was proposed to us basically sets up a similar sort of crime for aiding and abetting and carrying out these 2 particular sections and utilizing the law of war within Lane County. So, if there is an issue about whether or not it's clear in that ordinance about culpable mental state, I think that's a technical issue that may be able to be resolved within the ordinance. So I just want to make sure that that's clear, that that's not an absolute roadblock to us. The second issue I'd like to address maybe is the awareness of whether it's unconstitutional or not. How would they know it's determined to be unconstitutional? I don't think that the ordinance is specific to whether it's constitutional or not. It's about whether we're carrying out rules of war, the law of war, and that's very specific. And it means that you wouldn't get a civil warrant to carry out an arrest. You wouldn't get a civil warrant to provide personal information about somebody. I mean, that's a pretty easy test.
Yeah. Regarding the National Defense Authorization Act issue, I think Lane County needs to move forward with an ordinance. And I want to join the board in requesting that more time and in excess of 15 minutes be spent on putting together an ordinance.
In hearing the conversation about the NDA are 2 areas of concern by you, Mr. Dingle, and it sounded like it might be possible to include some language and also, apply the one area, not necessarily the court case, but as Commissioner Bozovich was find out. Just my question to you would be fairly simple for you to take the ordinance that's being proposed, put it in our typical county format, and make those couple tweaks and be comfortable with it and bring it back.
Like I said, I guess I misunderstood. As I read the preliminary material, the idea was to make what the court ruled in Hedges illegal or a crime. And so I'd have to go back and look at that. I also, I also would suggest strongly that since the person who's going to ultimately make the decision is Mr. Gardner, that he be involved in the process, because you can, pass whatever ordinance, but if he says he thinks he doesn't think it's constitutional or whatever, then he wouldn't pursue it.
The county's legal counsel then sought out the opposition of Lane County's district attorney, Alex Gardner, to put a halt to the passage of the ordinance. Mr. Gardner responded by writing a deplorable analysis of the ordinance, which clearly demonstrated his dangerous lack of understanding for the Constitution, as well as his responsibility as an oath-taking public servant. I understand the Board of Commissioners is considering an enactment of an ordinance proposed by PANDA, an anti-NDAA group. I reviewed a version of the ordinance and have many concerns. Although it is clear to me that the founders of the United States Constitution contemplated a much more limited role for the federal government, it is equally clear that the battle has long since been lost through decades of federal expansion. To the extent that the battle is worth continuing, it must be waged in a form of appropriate jurisdiction. I can't imagine Lane County wants to carry this question to the federal Ninth Circuit Court of Appeals as a defendant in a civil suit. As a friend of mine recently pointed out, local jurisdictions are free to adopt a nuclear free zone ordinance, But the leadership of those jurisdictions shouldn't assume that the federal government will thenceforth direct military nuclear-capable aircraft and nuclear naval vessels to take wide berth around their jurisdictions. The federal government has an expansive interpretation of the Supremacy Clause and every related authorizing statute, so our military will continue to fly or navigate wherever necessary to defend the United States, and such decisions will be made without regard to local ordinances. This comparison between PANDA's proposed ordinance and an ordinance prohibiting nuclear power clearly demonstrates the lack of constitutional responsibility of Lane County's DA. Unlike prohibiting nuclear energy, the Constitution explicitly prohibits the federal government from denying anyone the right to a trial and other due process protections. Similarly, under the 14th Amendment, states are also prohibited from depriving anyone of life, liberty, and property without due process. So, even if the federal government ignored the local ordinance, it would still be completely unlawful for any county resources, including staff, to knowingly assist in such unconstitutional actions. It was after the letter from the district attorney that Lane's legal counsel created a number of political and financial threats to stop the progress of the ordinance. These threats were used by all but one of the commissioners as political cover to deny the residents the ordinance they originally publicly supported. Each potential threat provoked a different critical question that was never asked by any of the commissioners. Threat number 1. The ordinance would be too expensive to implement because of the cost of negotiating new employment contracts with some of the county's labor unions.
Out of the 4 unions and associations we have talked to, 3 out of the 4 have been very clear that if these ordinances were moved forward, there would be a demand to bargain from those unions. Be aware that there would be significant costs associated with bargaining with those unions and associations over these ordinances. The obvious cost would be the county resources and time that we put in by both the employees on the bargaining team and the staff with pushing those matters forward.
Critical question not asked. Why do county employees' contracts need to change, especially those working for the sheriff's office, to assure residents their simple right to a trial? Threat number 2. The ordinance could violate federal grant requirements, resulting in the loss of necessary grant money.
For a lot of the grants, I should say that the department sees, specifically LCPOA and some of the grants under that impact the membership of FAPO, they have standard conditions in them that say that Lane County shall comply with all provisions and all state and federal laws, and that is a condition of the receipt of funding under those grants. So there was a concern that was expressed by the unions and associations of how that would impact those grants and continued funding from the federal government.
Critical question not asked. Does the acceptance of federal grant money overpower government officials' legal oath to uphold and support the Constitution? Threat number 3. County employees wouldn't know which law to follow, the NDAA or the county ordinance.
Well, as we were exploring this with our unions, they were talking a lot about the federal funding piece and brought up a lot of different agencies that we work with very closely, and one of those certainly being FEMA. So I'm finding that a lot of the employees that we're speaking with are feeling conflicted about which law they would then be required to comply with.
Critical question not asked. Are county employees really unsure if they should assist military operations to detain and potentially disappear residents without the proof of a warrant or confirmation from a judge? If anything, this question affirms the need for an ordinance to provide legal clarity for the employees of the county. Threat number 4. The commissioners could face personal legal consequences for passing the ordinance if it was later ruled unconstitutional.
Or that if the ordinances are deemed to be unconstitutional, then there is a potential for legal liability for the county and possibly even individual commissioners if there was a lawsuit that was pushed forward and there wasn't coverage under either the Oregon Tort Claims Act or the federal civil rights law.
Critical questions not asked. Are elected officials not protected for exercising in good faith their oath of office to uphold and support the Constitution? And is Lane County's legal counsel unprepared to defend the commissioner's obligation to their oath? After all the threats were made, now more than 8 months after the crowded public hearing, the commissioners were asked one final time if they would continue working on an ordinance to protect the rights of their residents.
At the end of the public hearing held here in April of 2014, Chair Commissioner Pat Farr directed staff to draft a resolution and an ordinance addressing the concerns made by dozens who made public testimonies in front of you and the 300 people in attendance. 2 months later, staff returned with a well-researched and well-written resolution. The resolution stated, quote, Lane County will not provide public resources to assist federal agencies acting under detention powers granted by the NDAA or any other federal authorization of force that could infringe upon constitutional freedom of speech, religion, assembly, privacy, or the right to counsel, end quote. It's completely unacceptable for oath-taking public servants to pass a resolution acknowledging the real dangers of the 2012 NDAA, declare that no county resources will be utilized in its implementation, and then refuse to pass an ordinance that legally binds anyone to those statements. As the legislative branch of the Lane County government and under the authority of Oregon's County Home Rule, you have the right to enact such ordinances. Although the county sheriff and the district attorney have the right to choose how they will enforce the ordinance, by no means should it prohibit you from upholding your constitutional duty to pass laws that support the constitutional rights of your constituents. Additionally, the potential cost of bargaining with Lane County employee unions is a small price to pay to not only educate Lane employees about the new federal executive power to indefinitely detain American citizens without a trial, but assures that none of our future tax dollars will be spent assisting in such unconstitutional acts. I am asking you, the commissioners, to put the NDAA ordinance back on the future agenda list for 2015 and to direct staff to either modify PANDA's proposed ordinance or draft an ordinance of their own that supports the statements you all made in your signed resolution.
If we had a work session on what those other states and committees were doing, it might result in us saying, no, we didn't want to pursue it further, but I don't think we ever really got much of a review. In fact, I think it's fair to say we asked for a review and didn't get a review of what these other communities and states were doing. So that would be my request, is we think of this as a work session. What are other communities doing? Show the public that we're not going to use our resources to cooperate with a law that many people believe is unconstitutional.
You know, many of us have taken oaths. We've all taken oaths of office, different offices, different times. I've taken an oath when I joined the U.S. Army. I took an oath when I became a commissioned officer in the U.S. Army. But I took another oath that most people in this room, in fact, perhaps nobody else in this room took. I took an oath to be a citizen of the United States. Everybody else, I think, was born with that. And a part of my oath, which carries, maybe even greater liability than my oath of office, it states that I will perform non-combatant service in the armed forces of the United States when required by law, that I will bear arms on behalf of the United States when required by the law. I don't think anybody else has taken that particular oath. Mr. Stewart.
Thanks, Mr. Chair. As I harken back to the conversation we had at the end of the year, it was, some pretty good information was presented to us and concerns with, our own labor units, with the prosecuting attorneys, concerns with our different departments that receive resources from the federal government. Do we suddenly become non-compliant with those grants that we've received? And I harken back that we've adopted probably one of the strongest resolutions in the United States against the NDAA.
The one thing that's different from the resolution is, if you will, aspirational. So it can speak in very general terms. However, when you create an ordinance that is criminalizing behavior, it's going to be judged by a much stricter standard.
I believe, other than the update that's coming before us, I'm not supportive of any additional work on this.
Any other comments? Commissioner Leiken.
Thank you, Mr. Chair. I believe that Commissioner Stewart pretty well said what was on my mind as well. I think we have a good, solid resolution in place,
And I think at this point in time, I'm satisfied where we are.
You know, my interest in this, is to protect the rights of our citizens. At the same time, we have to balance the protection of those rights with our duty to our oath to uphold the laws of the United States, and also to our fiscal responsibilities to the citizens. The last update we got from legal counsel, I believe, was in December of last year, was so devastating about the negative impacts of a county ordinance. And at that time, we basically looked at each other in stunned silence and let it die. And I'm not really willing to bring it back for a work session this time, because nothing's changed about those legal opinions. Unless somebody can bring me, sufficient legal counsel that says our legal counsel was completely wrong and this is what the balance to that is, I can't look at that and go, wow, I'm really willing to keep moving forward with this, even if some other jurisdiction in some other state, which might have completely different liability and legal restrictions on them, has done something else. So, difficult place to be in, and difficult balance for the board, but I don't support setting up another work session until we hear something different, either from legal counsel or legislative committee, that there's been a change. And I'm seeing at least two head nods to the side of me. I thought I heard you express you weren't interested, so I believe that this item will be tabled this time for lack of three assents from the commission.
Despite all the political and financial roadblocks that drastically shifted the commissioner's opinion and their perceived responsibility to their oath of office, citizens also attempted to pass Panda's proposed law at the state level. Panda's proposed law, along with the resolutions signed by the officials of 5 different counties, were given to Floyd Przansky, chair of the State Senate Judiciary Committee, to introduce to the state legislature. Mr. Przansky didn't believe the state had the power to pass such a law because of his interpretation of the Supremacy Clause. This is the legal belief that federal law trumps state law in every instance. In this case, and in Mr. Przansky's opinion, even federal laws that deny the constitutional rights of Oregonians must be followed. Mr. Przansky was the state senator for the residents of 2 of the 5 counties who signed resolutions against the NDAA. To entertain his commitment to his constituency, as well as to his oath of office, he sent the proposed law to the state's Legislative Legal Council to confirm his constitutional understanding. The state's Legislative Council is an unelected group of attorneys who gives legal advice to the state's elected officials. Although claiming to be nonpartisan, their legal interpretations are often politically motivated. When the legal examination of Panda's proposed law was finished, the written analysis was absolutely astonishing. Its findings should be deeply concerning for every American, particularly those in Oregon. The written legal analysis from Dexter Johnson of Oregon's Legislative Council made the following frightful determinations about the 2012 NDAA and Panda's proposed law. Number 1. He determined that Section 1021 does in fact allow military detention of American citizens inside the United States, and acknowledged that they could be imprisoned until the end of the War on Terror without the right to a trial. Number 2. He acknowledged that this included Americans who have been merely suspected of committing the vague action of a belligerent act against the U.S. Number 3. He determined that Panda's proposed law would in fact criminalize those actions authorized by Section 1021. Most importantly, number 4. He determined that Panda's proposed state law would directly conflict with the indefinite detention powers granted by the NDAA, a federal law. He then quoted the controversial Supremacy Clause, noting this modern and drastically expanded interpretation concludes that any time state laws conflict with federal laws, state laws are always deemed unconstitutional. And finally, number 5. He ended his written analysis by determining that the appropriate way to challenge the constitutionality of the NDAA is not collaterally through the states, but for someone who's been personally targeted by the NDAA to sue in court. In other words, we must wait for someone who's been militarily captured and detained without the right to a trial to somehow get a trial to sue in court. the irony shouldn't be lost to anyone. This modern interpretation of the Supremacy Clause is the main reason behind the utter destruction of the Federalist form of government and the extra layers of protection it offers to the rights of the people. If states and local governments can't protect the most basic and explicitly guaranteed rights in the Constitution from federal abuse, there's absolutely no limit on how far our rights can be eroded away. The single biggest roadblock that prevents local governments from protecting the constitutional rights of the residents from federal abuse, like the NDAA, is their own elected and unelected officials' interpretation of the Supremacy Clause. Despite the partial and conveniently quoted Supremacy Clause written by Dexter Johnson in his analysis of Panda's proposed state law, a more complete quote of that clause drastically clarifies its original intention. It very plainly says, for the law to be considered a supreme law of the land, the law must be made in pursuant of the Constitution, or in other words, it can't conflict with the Constitution. However, the federal NDAA authorizes the military capture and detention of American citizens and denies them the right to a trial for potentially the rest of their lives. By no means is this in pursuant of the Constitution. It explicitly violates a number of sections of the Constitution as shown here. These areas of the Constitution assure the right to a trial even in cases of high crimes and treason. Those who challenge this original intention of the Supremacy Clause will point out the long-standing precedents set by the courts. However, none of those previous court rulings deal with the type of federal abuses currently being carried out in the name of national security. When interpreting the Constitution, most often people only consider the legal precedents set by the courts. But it's equally, if not more important, to analyze the well-documented discussions of those who wrote the Constitution, as well as those who ratified it into law to truly understand its contractual meaning. Before the Constitution was even ratified into law by the states, many people brought up the deep concerns about the Supremacy Clause and its potential to destroy state sovereignty. Alexander Hamilton and James Madison eased people's concerns by arguing that it did no such thing. Alexander Hamilton defended the Supremacy Clause at the state of New York's ratifying convention by saying, and I quote, "The word supreme import no more than this, that the Constitution and the laws made in pursuance thereof cannot be controlled or defeated by any other law. But the law of Congress are restricted to a certain sphere, and when they depart from this sphere, they are no longer supreme and binding." End quote. Similarly, James Madison, considered the father of the Constitution, wrote Federalist 45, an essay meant to convince the states to ratify the Constitution. He assured the public, and I quote, "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain to the state governments are numerous and indefinite. The powers reserved to the several states will extend to all objects which, in the ordinary course of affairs, concern the lives, liberties, and properties of the people and the internal order, improvement, and prosperity of the state." End quote. Similar evidence supporting the original understanding of the Supremacy Clause can be found from statements made by a number of other influential people who attended state ratifying conventions. Those included Noah Webster and Thomas McKean in Pennsylvania, James Iredell in North Carolina, and Roger Sherman of Connecticut, just to name a few. As addressed in part 1 of this video series, since the beginning of the War on Terror, there's been a trend of newly passed federal laws that are either written or secretly interpreted in ways that are not in pursuant of the Constitution. The system of federalism is meant to assure that the Constitution is upheld and supported by each branch and at each level of the government from the top all the way to the bottom. This support is required and reinforced by state and federal laws requiring these individuals from all branches of the government to pledge an oath of office to uphold and support the Constitution. This oath, combined with the principles of American federalism, give the right to the federal government to assure that local jurisdictions are not infringing upon the constitutional rights of their residents, like we've seen before in cases surrounding issues of discrimination, segregation, and equality under the rule of law. However, our federalist system also provides that same responsibility to the states to assure that the federal government isn't violating the rights of the people, as we're beginning to see more and more since the beginning of the War on Terror. Luckily, the revitalization of the federal system and the additional protections it provides to our civil liberties doesn't have to trickle down from Washington, D.C. With an informed public, the protections of federalism can take root and grow throughout communities and states until it dominates the political sphere. It is up to citizens in every state to only elect individuals who prove they understand the responsibility of their oath of office, the original intent of the Supremacy Clause, and the courage it takes to defend their residents' constitutional rights despite the excuses and legal threats they may encounter. Additionally, county and state legal counsels, the people who are selected to give legal advice to our elected officials, are rarely themselves elected positions. This often makes them and their legal opinions less accountable to the people they serve and more influential to the federal and corporate pressures they receive. It's important that communities attempt to make these publicly funded legal counsels elected positions. If they can't, it becomes even more essential to only elect individuals who have proven a solid understanding of the Constitution and the founding principles of our Federalist form of government.
What you're seeing since 9/11 is the executive branch is subverting the Constitution. They want to take the power under themselves. They're betting, they have to, betting on a compliant Congress, a complicit Congress, and a judiciary that's not going to stand up to them. So what they end up doing is they will force certain kinds of enabling act legislation through Congress to make legal. That's the ex post facto side that was once illegal. The FICE Amendments Act is certainly a case in point. The other thing they'll do is they will do signing statements, or they will secretly interpret the existing legislation that doesn't suit their needs in terms of the national security state. That's precisely what was done with the Patriot Act. I was a senior executive of the National Security Agency, and to my utter horror, I discovered within weeks of 9/11 that the National Security Agency, headed up at the time by Lieutenant General Michael V. Hayden, had entered into a secret agreement with the White House in which the White House had made NSA the executive agent for the tippy-top surveillance program, the so-called warrantless wiretapping program. I found that out, and I raised my concerns, alarms, within NSA. First week in October 2001, I had the most chilling of conversations with a senior attorney at NSA who made it unmistakably clear that NSA had become the executive agent for the White House. It was all legal. The White House had approved it, and you do not want to ask any more questions, Mr. Drake. Don't go there. I knew in that moment, that was my moment of truth, I knew in that moment that what I was an eyewitness to was a very subversion of our own Constitution. And I knew in that moment, in that very moment, that not only had the wheels come off a 23-year legal regime, and the wheels had come off the Fourth Amendment in secret, that we were in an entirely new vehicle. This was not a constitutional form of government. This was an alien form of government. It was a secret government being run by executive rule. And everything that has happened since 9/11 has simply increased the power of that secret government. The Constitution for them is just a piece of paper. It's an inconvenient truth. It's not a grand experiment. We don't really have constitutional government in this country anymore. It is a figment of our imagination. It is hollowed out Constitution. So the NDAA takes it to the next level. Not only was I prosecuted and indicted, and at one point facing, as the original prosecutor said quite clearly during an interrogation session at a secret FBI facility in the greater DC area, how would you like to spend the rest of your life in prison, Mr. Drake, unless you start cooperating with us? We might let you off for 15 or 20 years, maybe. That's what's facing this country. I was charged on the Espionage Act. That's the most egregious thing you can charge an American with. I was behind several 8-balls when they indicted me. 5 counts under the Espionage Act. But this takes it to the next level. At least I had access and recourse to the judicial system, and in fact, a third branch of government stood up to the government during my sentencing hearing on July 15th, 2011. What we're seeing with the NDA is something that's even more sinister. They're designed to ensure the increasing reality of an imperial presidency.